Good afternoon, Year 12s. Today I'm talking to you about how you can use social media without getting in trouble for defamation. Let's have a quick look at the start of our topic. And what has to happen for defamation from the Defamation Act 2005 in Queensland? A matter has to be published, has to be communicated to at least one person. You can probably see how social media does this straight away. It has to contain something that damages the reputation of the person. And it has to refer to the person. It doesn't have to name them, but people have to be able to identify who it is. So publication is producing a document that can be viewed in different copies. So a tweet, a Facebook post, or Instagram would all be publication. Let's have a look at this, a case. Allergy Pathways was a company. They were banned from making claims in their advertising material. But on their Facebook page, they had followers that continued to make these claims, so like medical claims or claims about what their product could do. And the justice in the case decided that having these claims, even though they weren't made by them on their Facebook page, was actually publication. So you can see publication may not be just as simple as something that you've said. It could be content on your Facebook page as well. So people are allowed to protect their reputation in the community. And I've given a number of defamatory statements there that you can see. They're statements that people might make in the heat of a moment or an argument or something like that. And the third part of defamation has to refer to the person, as long as a reasonable person would know that it's referring to them. Here's an interesting case around defamation. This happened up in North Queensland. Someone's email account was broken into, and the person who broke into the account then sent this email that they claimed was a joke, saying that the person's email who'd been hacked was gay and that they were looking for a relationship. So is it defamatory? Has it been published? Yes, it is. Is it injuring their reputation? Yes, because it makes them come across as promiscuous. I also would suggest it makes them come across as socially incompetent. That's not the sort of email a normal person would send. And did they suffer a loss? Yes, they did. They were ridiculed and they left the workplace. And that element of loss is very important. And the judge awarded $100,000 in damages. Now, this is a case here where a story has been written about homelessness. And a comment's made here, Abbott would be winking and licking his lips at the homeless youth that are there to be exploited like rich men like him. So the question is, as a case study, could this potentially be defamatory? Well, has it been published? Absolutely. Has it damaged the reputation? Well, there may be some argument around this in terms of the fact that, is it clear what is implied? You know, is the licking lips, is what style of exploitation is clear? But even that word exploitation, I think, suggests that it's damaging the reputation. He is being painted as someone who would exploit children, even though it's not clear exactly how. And does it identify? Yes, it does. What are some possible defences? Well, honest opinion. I don't think that honest opinion would be reasonable in this situation. I don't think there would be any basis to hold that opinion that Tony Abbott likes exploiting children in whatever form. Is it the truth? Unless they have some evidence that we're not aware of. Triviality, you might talk about the fact that it was in the context of a story and not a huge deal as a Facebook post. But I think that if that went to a court situation, it would be very interesting to hear. And I think that it would not be the sort of social media comment that you would want to go to court with. Okay. If you've defamed someone, right? First of all, things you might do: publish an apology and offer some reasonable compensation. It's important to know that this offer is not made with any acknowledgement of guilt. So it won't affect what happens if there was a trial as well. We talk about some defences: triviality, it's a plaintiff unlikely to sustain any harm; honest opinion. Remember, you can't have an honest opinion about something that can be a fact or not. Anonymous. Right? So there was an anonymous case where someone just under the name Witch, they ended up having to pay compensation for a defamation situation. So some recommendations for high school students. Right? First of all, you publish when you're on social media, so you have to be thoughtful about that. Think about whether what you're publishing has a potential to damage the reputation of someone, and go through the process of making amends if you need to. It's important thinking whether the law around social media is fair and just. And I would suggest one thing that we need to think about here is whether people have enough understanding. So the key stakeholders is people using social media. Do they have enough understanding that they are publishers? And that's where I'd like to see the 2005 Act amended so that any time people engage with social media, they are reminded that they are a publisher and they have responsibilities that go with that. These could be outlined in a very clear, simple statement when people sign up to a social media account in Australia, and then a reminder each time that they log on. It wouldn't take a lot of effort, but it would help get past that point where people say, I didn't realise that what I was doing was publishing and that I had the potential to defame people. One thing to think about, one final thought, is that when you publish, other people might share what you've published or retweet or print, or even news articles often pick it up and publish people's tweets. So you could have material that you've written, opinion you've made, shared very widely. You have a significant responsibility as a publisher, and it's important to keep that in mind.